How are you, sir? Fine. How many left, man? Yes, sir. When? Yesterday? Day before. Conviction of hell.
No order as to cost. Question of maintainability is well settled. It is too late in the day to entertain all those questions of maintainability. सत्य पासे 13 है, तुम्हारे 12 दिलाम, जाओ.
Amit Khan was here.
Delhi.
Is it Delhi? Yeah, on mine. What? Mine.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1, pronouncement of judgment.
We have, on the issue of jurisdiction, we have said that there is no limitation on the powers of the governor in carving out a part of what is conferred and placing it on other. We've also referred to the mere failure to indicate the authority would not vitiate as long as the power is there. We've also dealt with the second paragraph and the mischief that you... And we've ultimately said that since no irregularity, far less any illegality has been found in the conduct of the criminal trials as in the present case, the validation of the trial conducted in this case need not be on the crutches of the second paragraph in the relevant notification of 20th September 2022. And we have said that the trial court in this case had due authority in terms of the notification of 3rd May 2018. We've also specified that if parallel proceedings are going on elsewhere, they cannot any longer go on in view of that. So that is something we don't know. And then on merits, we have said that even with such strict tests in mind, since the conviction in this case is based on circumstantial evidence, it cannot be said that there is any missing or weak link that leads to any reasonable doubt as to the culpability of the appellant. Strictly speaking, the deceased may not have been last seen with the appellant before her lifeless body was discovered, yet in the quite believable evidence of her sister and the mother of the deceased that the appellant herein followed the deceased after she left the house, there is sufficient proximity of the appellant established with the deceased. At any rate, there is nothing to doubt that the appellant led the police to the place of occurrence and confessed to killing the deceased in the presence of several persons, including a sister of the deceased. With the appellant's proximity to the deceased being established, the place of occurrence being found to be close by, and a weapon being discovered therefrom which could inflict the injuries discovered on the person of the deceased, the chain is as tight as possible in the absence of direct ocular evidence. And we have not interfered. Thank you to everybody.
Obliged.
it will be available on the server this afternoon.
Item number 2. Item number 1.
May I please, Lordship?
Yes.
Lordship, this is the GST on royalty matter, and
Sorry?
the royalty matter is still pending. GST on royalty matter, Lordship,
And Supreme Court
and it is
decided.
No,
it is still pending.
Very well. Since
Still pending.
the issue pertaining to whether GST would be payable on royalty is still pending before a constitution bench, let this matter appear a further 8 weeks hence. Will stop. Paragraph, the parties will have liberty to mention for an early listing upon the conclusion of the matter before the Supreme Court. List on, give it about 8 weeks. Yes.
My lord, it's not a constitution bench, my lord. It's a regular bench, a normal bench.
Before a larger bench.
So before 2 judge bench only.
Only.
This issue was never decided earlier.
Then, whereas you said constitution bench, they will say before the Supreme Court.
Item number 2.
Oh, that is whether royalty would be a tax or not. That is pending before.
Royalty is in the nature of tax or not? Lordship?
Yes, well, that is pending before the constitution bench. This is GST on royalty.
GST and royalty.
Yes, yes.
GST on royalty will be double taxation.
My lord, that is the issue.
Item number 2.
We'll follow that order and pass the same order.
I'll provide copies. My lord.
Yes. Thank you. The facts in this case and the legal issues that arise as a consequence are, as the parties graciously submit, the same as in WPC number 236 of 2020, full stop, paragraph. The writ petition in WPC number 236 of 2020 was directed against a judgment and order of March 15, 2019, passed by the Guwahati bench of the Central Administrative Tribunal, The order a similar order dated
March 15th, 2019, madam.
a similar order of the same date passed by the same tribunal is assailed in the present proceedings. Full stop.
Only the post is different, my lord.
WPC number 236 of 2020 was disposed of by reasoned order of this court passed on November 29, 2021, and without interfering with the judgment and order of the tribunal that was questioned therein. Full stop. Paragraph. The present writ petition has remained pending for a considerable period of time since the union had carried a petition for special leave to appeal from this court's order of November 29, 2021 in WPC number 236 of 2020 before the Supreme Court. However, the petition, the special leave petition was withdrawn on the submission that the union would approach this court for a review of the relevant order. Full stop. In pursuance of such submission and the consequent leave obtained, MC bracket review petition number 7 of 2022, review petition number 1 of 2023 was filed. Full stop. Such review petition number 1 of 2023 has been dismissed by a recent order of February 9, 2023. Full stop. Thus, the original order on similar facts and the same legal issues passed on November 29, 2021 remains undisturbed. Paragraph. Accordingly, since there is no dispute that the facts in this case and the legal issues involved are as in WP bracket C number 236 of 2020, the present petition, WP bracket C 76 of 2021 is dismissed, and the judgment and order of the tribunal challenged herein dated March 15, 2019 is left undisturbed. Paragraph. There will, however, be no orders to cause.
The
I need a question.